Good morning, good afternoon. I'm Lisa Sotto, and I chair Hunton's Privacy and Cybersecurity practice. I am delighted to welcome you to today's webinar on the California Privacy Rights Act. California voters approved Prop 24, which is the CPRA. We have a lot of alphabet soup of initials during this presentation. And the CPRA will significantly amend and expand the CCPA, the California Consumer Privacy Act of 2018. Before we begin, I'd like to just note a couple of administrative details. We are recording this program and we'll make the recording available after the webinar. If you have questions during the program, please use the Q&A feature that you'll find at the bottom of your screen, and we'll take questions if we can at the end of the program as time permits. And I'd like to introduce you now to our speakers. Joining me for the next hour are Brittany Bacon, who is a partner in Hunton's New York office. Brittany has received national recognition for her work in the areas of privacy and data security, and her work includes leading many CCPA projects and assisting clients in building their privacy compliance programs generally. Also with us is Aaron Simpson. Aaron is also a partner in our New York office who brings a really unique transatlantic perspective to this conversation. Aaron spent the years in the run-up to the GDPR's effective date as the managing partner of the firm's London office and the head of our European data protection team. Aaron is recognized globally for his work in this area, particularly with respect to the GDPR and now the CCPA, and he also manages quite a number of privacy compliance projects. So with that, let's just dive right in. Just to give you our perspective at Hunton, if we can go back to the previous slide, please. Sorry, thank you. So at Hunton, we are 45 people in our practice who do nothing but privacy and data security globally. We are in the US, London, Brussels, Beijing, Bangkok, and the UAE, and we're supported by a local council network of over 100 local council in very specific jurisdictions. We represent clients across industry sectors, so we are constantly analogizing as between industry sector, because of course this is still a nascent area of the law, so we need to pull in knowledge from other industry sectors. Many of you know about our Center for Information Policy Leadership. I would recommend going to that website if you are interested in any number of very detailed papers on specific issues in connection with the GDPR, the CCPA, the possibility of a federal privacy law, and many other topics. And then I would commend you to our blog, huntonprivacyblog.com, where we post 3, 4, 5 times a week on privacy and data security issues around the world. And we have a Twitter handle, which is shown here as well. Next slide, please. So it has been quite a wild ride with the CCPA. First, the CCPA was enacted under really quite unusual circumstances. And then we all scrambled to comply, and we had a little bit of time to do that, about 1.5 years. And now we need to completely regroup and consider what changes are necessitated now by the enactment of the California Privacy Rights Act, which will amend the newly affected CCPA, really. So we're going to spend some time with you this morning or this afternoon to talk about the current state of the CCPA. We'll talk a little bit about the regulations and enforcement trends, and then we will dive headlong into the new kid on the block, the CPRA, which, as you all know, passed as a ballot initiative on November 3rd in California as Proposition 24. We'll focus on the CPRA's similarities to the GDPR as well, and there are some striking similarities and some languages just mimicked directly from the GDPR, which is interesting in terms of taking our lead from the GDPR and understanding how DPAs are enforcing certain issues in the GDPR that might translate over to enforcement in the US under the CPRA. And then finally, we'll give you some implementation tips. How do we do this? How do we operationalize all of this? Next slide, please. And one more. Thank you. Well, it is no accident that the CCPA sprang up on the heels of the GDPR's compliance deadline in May of 2018. Following in the wake of the passage of the GDPR, we also had the Cambridge Analytica issue that really marked, I think, a line in the sand and catapulted consumer data privacy to the forefront of US political and social discourse. I mean, this was just front page news for a long time. The CCPA was passed very quickly by California lawmakers in an effort to remove a ballot initiative that had the same name from the November 6, 2018 ballot. And by mid-May, the proponents of the ballot initiative had agreed to withdraw the initiative if the legislature passed a law, which they did. And that law was passed in June, and it was amended then 6 times in September and October of 2018. So I think it's fair to say that from the moment of its passage 2.5 years ago to today, the CCPA continues to make headlines time and time again. We've said this many times, but it bears repeating. It is the only comprehensive general privacy law in the United States. It is more in line. It's certainly not perfect by any means, and not identical to, but it's more in line with global data protection laws in that it is a comprehensive law than anything else we have in the United States, which are, of course, sectoral in their coverage in the US. I'll just note that the compliance deadline for the CCPA was January 1, 2020, and the enforcement deadline was July 1, 2020, so everybody was sort of scrambling there. The regulations have been modified now 4 times. One of them was just an error, so maybe it doesn't count as a 4th, but for the sake of completion, it was really 4 times that the regs were amended. They finally became effective on August 14th, and then there were more amendments. So this has been really a painful ride, and it will only get more painful as we go. Of course, the ballot initiative came to pass on November 3rd. But back one, please. Okay, thanks. The ballot initiative came to pass on November 3rd, and I will just note that the compliance deadline for the CPRA is January 1, 2023. The deadline for the adoption of final regs is July 1, 2022. And there's a look back period to January 1, 2022. So we need to keep that in mind as well. And Brittany's going to tell us all about that. And the enforcement deadline for the CPRA is July 1, 2023. So never a dull moment. Next slide, please. Okay, so I'm just going to, before we hit the CPRA, I'm going to give a quick overview of the CCPA, and then we'll talk a little bit about the regulation, the amendments and the regulations. So the CCPA really did change the landscape in the United States, and I would bet that a number of state legislatures are going to take this issue of privacy up in their next session as soon as they stop focusing all exclusively on COVID. I think we're going to see some action in various state legislatures on other state privacy laws. So keep your ear to the ground on that. So the CCPA generally grants consumers rights over their information. Of course, there is the right to know. We think of this sort of globally as the right to access one's information, but it's known as the right to know in California. There is the right to delete information under the CCPA, and the right to opt out of the sale of data with this dreaded definition of sale. That's extremely broad. There's a requirement to provide privacy notices with specified and cumbersome content. These are not easy to read or attractive privacy notices. They are what they are. There is also a requirement under the CCPA to contractually restrict certain activities of service providers that process a business's personal information. That those contractual obligations have been expanded under the CPRA, which we'll hear about shortly. There is, of course, mandatory training, which will have to be revamped in light of the CPRA. The compliance deadline, as everybody knows, was January 1, 2020, with enforcement July 1, 2020, although the regs were not, had not been finalized by then, but were finalized a little bit later. And I'll also just note that there have been two amendments to the CCPA in September of 2020. One of them is moot. It would have extended the moratorium with respect to HR data and B2B data to January 1, 2022, but that is now moot in light of the CPRA, which extends the moratorium on both HR data and B2B data to January 1, 2023. And the other amendment was to establish new exemptions for certain types of medical and health information. And if you're very focused on this, this was Assembly Bill 713. All right, let's go to the next slide, please. The regulations. We waited and we waited and we waited for the regulations. And then we finally had to ingest, as I said, 4 separate versions of the regs. Again, one was just to correct an error, so it's really 3 modifications. The regs have gone through regulatory contortions. But now they're here. They went into effect August 14th. So, so here we are. So let me just also, I'm not going to go through this, the regulatory machinations in detail, but I do want to hit the last set. So on October 12th, just last month, the Attorney General issued another set of proposed modifications to the already effective regulations, and the modifications would revise portions of the regs relating to the notice of the right to opt out, the methods for submitting opt-out of sale requests, as well as verification of authorized agents. The public comment period for these proposed modifications ended on October 28th. So we wait and we'll see what happens soon, I hope. All right, next slide, please. Okay, so beginning with the first draft of the regs that came out in October of 2019, all the drafts have covered similar concepts within the same framework. The regs address in really quite a bit of detail the various notices to be provided to consumers, and these are, of course, the notice of collection, notice of the right to opt out, the notice of financial incentives, as well as the privacy policy. The regs also provide instructions to businesses for receiving and responding to consumer access, deletion, and opt-out of sale requests, and they provide detailed information on how businesses should verify consumers' identities. One of the most controversial aspects of the regs are the rules around data valuation, and businesses continue to this day to struggle in how to appropriately calculate the value of consumers' data. And this is required where a business is providing certain financial incentives like most loyalty programs. The regs also provide for a number of additional permitted uses for service providers, so they can use personal information they obtain in providing services for certain limited uses. And this is a real positive for service providers as well as for businesses. The regs also contain requirements on training and on record keeping, including the other dreaded provision in the law on publishing metrics. So if the business annually processes data of a certain specified number of California consumers, there is a requirement to publish metrics, and that would, the first deadline for that would be this upcoming January 1, because it's a look back of the prior year. The regs do not provide clarity on some critical aspects of the law, like determining whether a disclosure constitutes a sale, or providing clarity on what businesses need to do in response to a request for specific pieces of information. And this only gets harder when we start to think about HR data, because that's a particular quandary that we're going to have to navigate. Next slide, please. So the AG's office, the California Attorney General's office, began enforcing the law on July 1, 2020. And as we'll hear, there's going to be another agency that's now going to take up the mantle on enforcement. It will no longer be the AG, and that's new under the California Privacy Rights Act. And I'll just also note there have been a lot of articles saying this is going to be the first privacy office in a state. That's not the case. If you all may remember that Joan McNabb headed up the California Office of Privacy Protection, which was then absorbed into Kamala Harris's AG's office. So not the first, but certainly this new agency is going to have a much higher profile and be an agency that we absolutely will want to keep our eye on closely. So just to give you some sense of some of the penalty provisions, the substantive provisions of the CCPA, which again are enforceable by the AG, could result in civil penalties up to $7,500 per violation. Boy, that's a huge amount when you think about multiplying that out. Under the CCPA, a business has 30 days to cure a violation after notification of noncompliance, but beware, the CPRA changes this. So when it comes into effect in 2023, the new agency will not be required to provide a 30-day cure period, but instead will have the discretion to grant a time period to cure an alleged violation. We are also aware that the California Attorney General started to send 30-day notices on July 1, these cure period notices, and we've seen a couple, and they're based on a failure to include a do not sell my personal information link. It's very easy for anyone to go on a website and see what ad trackers are on that website. So you really can't hide from the do not sell requirement. There's also, of course, a private right of action, but only for breaches of consumer personal information if an entity is deemed to not have reasonable security in place. And the dollar amount there is absolutely daunting. It's up to $750 per consumer, or actual damages, whichever is higher. There have now been several civil actions filed that raise allegations under the CCPA. And while it's early days, this is certainly a landscape that bears watching. Okay, with that, Brittany, I'd like to turn it over to you.
Okay, and next slide, we'll dive right in. So without further ado, while most of the country had their eyes on Georgia and Pennsylvania in early November, those of us in the privacy community had our eyes on California, watching as Proposition 24, which is the California Privacy Rights Act, the CCPRA, I'm going to have to get used to this, was on the ballot and was being voted on. On May 4th, the Californians for Consumer Privacy, the CCP, announced that they had collected over 900,000 signatures to qualify the CPRA for the November 2020 ballot. And as you probably recall, this is the same group behind the November 2018 ballot initiative that inspired the CCPA. The CPRA qualified for the ballot on June 26th and was voted on and ultimately passed on November 3rd. According to the CCP, the Californians for Consumer Privacy, Proposition 24 safeguards our kids' online privacy, reduces the threat of identity theft, and gives consumers the important privacy rights that we need to take back control over our personal data. They also go on to say that when big tech firms spent 2019 trying to water down our new privacy law, CCP filed an initiative to both protect and expand the CCPA. So you can see sort of the genesis behind these efforts. As Lisa mentioned, the CPRA amends the CCPA, which is why we call it CCPA 2.0, to create new and additional privacy rights and imposes obligations on business, which we will get to in short order. Most of the CPRA's substantive provisions will not be effective and operative until January 1st, 2023, which seems like eons away. But as we know from the CCPA, it takes time to get your compliance program ready and to go live by that time. The law also applies only to personal information that was collected on or after January 1st, 2022. Okay, so 1 year prior to the compliance deadline, except, and this is important, except with respect to access requests, which will extend further. So specifically, a consumer is going to be able to request that a business disclose their personal information in response to an access request beyond the 12-month look-back period, which is the current standard under the CCPA, and a business will be required to provide such information unless doing so proves impossible or would involve a disproportionate effort. This expanded access right will apply only to personal information collected on or after January 1st, 2022, and nothing in the CPRA will require a business to retain personal information for any length of time, such as to be able to comply with such access request. If we could go to the next slide. So some key concepts on the CPRA. Let's start with the most important. Does it apply to me? And to answer that question, we need to look no further than the definition of business. Business was defined under the CCPA, but the CPRA has amended the definition and in some ways has slightly narrowed the scope and in other ways is potentially expanding it. So let's break this down. Under the CPRA, a business means any for-profit, sole proprietorship, partnership, LLC, corp, association, or other legal entity that collects consumers, consumer meaning California residents, personal information, or on behalf of which such information is collected. The entity has to determine the purposes and means of the processing of consumers' PI, so very similar to the concept of a data controller under the GDPR. The entity has to, quote unquote, do business in California, which often is a very tricky question, particularly for companies that don't have a physical presence in California, don't have employees there, but may in fact collect California resident data, such as through their website, sort of inadvertently. So that's a fact-specific analysis that has to be examined. And finally, it has to satisfy one or more of the following three thresholds. So first, as of January 1st of the calendar year in question, the entity has to have had annual gross revenues in excess of $25 million in the preceding calendar year. And note, we've gotten the question a lot, you know, can you only be looking at revenues generated from California residents? Unfortunately, the interpretation is annual gross revenues across the board, regardless of whether it's from California. Second criteria, one of which needs to be met, is the entity has to alone or in combination annually buy, sell, or share, and this is important, the personal information of 100,000 or more consumers or households. So while they bumped up the number from up to 100,000, the change is that it's not just sharing for commercial purposes, it's sharing as defined, newly defined under the CPRA, which is sharing for cross-context behavioral advertising purposes. And what does that mean? It is defined. Cross-context behavioral advertising means the targeting of advertising to a consumer based on the consumer's personal information that's obtained from a consumer's activity across businesses, distinctly branded websites, applications, or services other than the business with which the consumer intentionally interacts. So that if done for 100,000 or more California residents, such as on your website, that would mean you qualify for that criteria. And last threshold would be you derive 50% or more of your annual revenues from selling or sharing, again, same definition, consumers' personal information. The CPRA also applies to any entity, and this is similar to what we saw in the CCPA, any entity that controls or is controlled by the business as defined above. So an entity that meets the criteria I just discussed. There's a slight change to and that shares quote unquote common branding with such business. Common branding is slightly revised now, so it means a shared name, service mark, or trademark such that the average consumer would understand that two or more entities are commonly owned. So that's the trigger for the common branding. Also new, another type of entity that would be captured within the scope of the CPRA is any joint venture or partnership that is composed of a business, capital B, like I described in the first section, in which each business has at least a 40% interest in such JV or partnership. The joint venture or partnership and each business that composes the JV or partnership shall separately be considered a single business. And finally, another type of entity that the CPRA could cover is what we call a voluntary business. And that is a person, which is an entity that does business in California, that is not covered by any of the criteria I just described above, or does not meet all of it as described above, and that voluntarily certifies to the California Privacy Protection Agency that it is in compliance with and agrees to be bound by this title. Why on earth? I don't know, but I think what we may see, and this is what the new privacy agency is being charged with, they will be creating a mechanism for companies to voluntarily certify, and they will be publishing a list of the names of such companies who've decided to voluntarily certify, which, using it as a market differentiator, we've heard this, certainly time and time again, privacy and data protection may be something that certain companies are willing to explore. All right, and I just also note that certain of the CPRA's requirements do apply directly to service providers, contractors, and third parties. Aaron will get into this a little bit, but this comes up more in the context of, with respect to certain rights, there is an affirmative obligation for these types of entities to cooperate with the relevant business and help them. There's also an obligation to notify a relevant business if that particular service provider or contractor engages a subcontractor. Okay, moving on to the next slide. All right, some key concepts, new consumer rights. Lisa went through the core consumer rights that were available and are available under the CCPA, namely the right to access, delete, and opt out of the sale of data. Now we have a right to correct personal information. This is very similar to the right of rectification under the GDPR and will be added to allow consumers to request that a business correct the personal information that the business maintains if such information is inaccurate. Next up is the opt-out of sharing. So we've been living and breathing opt-out of sale. We're now moving into opt-out of sharing as well. As I mentioned, the definition of sharing is really focused on sharing of personal information for cross-context behavioral advertising, whether or not, and this is what distinguishes it from sale, whether or not for monetary or other valuable consideration, including transactions between a business and a third party for cross-context behavioral advertising for the benefit of a business in which no money is exchanged. So I know one of the key questions we've been helping companies think through is, does my use of certain third-party cookies and pixels on my website constitute, quote unquote, a sale? And therefore, do I need to offer an opt-out right? This shift and recognition that consumers now have a right to opt out of sharing seems to try to clarify the point that, yes, that type of online behavioral advertising, cross-contact behavioral advertising as defined under the law, is something that they intend to allow consumers to opt out of. Okay, moving on to, let's see, oh, sorry, go back to the prior slide. Okay, another important right afforded under the CPRA is the right to limit the use and disclosure of quote unquote sensitive personal information. So this is a new concept under the CPRA. It is defined. It means personal information that reveals, one, a consumer's social security, driver's license, state ID card, or passport number, so pretty common. Two, a consumer's account login, financial account, debit card, or credit card number in combination with any required security or access code, password, or credentials allowing access to an account. Third, a consumer's precise geolocation data, so that's officially considered sensitive personal information under the CPRA. Next, a consumer's racial or ethnic origin, religious or philosophical beliefs, or union membership. Next, the contents of a consumer's mail, email, and text messages, unless the business is the intended recipient of the communication. So again, that data is going to be considered sensitive personal information. A consumer's genetic data is also sensitive PI. And finally, the processing of biometric information for the purpose of uniquely identifying a consumer, personal information that's collected and analyzed concerning a consumer's health. And finally, PI collected and analyzed concerning a consumer's sex life or sexual orientation. So a very expansive definition of sensitive personal information. And now under the CPRA, a consumer will be able to ask a business to limit the business's use or disclosure of the consumer's sensitive PI to, number one, only that which is necessary to perform the services or provide the goods that are reasonably expected by an average consumer who requests such goods and services. Two, to perform specified enumerated business purposes, which we know is defined as by the CCPA, or three, as authorized by forthcoming regulations. So stay tuned on that, but that is a pretty significant change from a CPRA perspective. Finally, moving on to the next slide. Okay, so for those of you who have been updating your privacy notices and making sure by January 1st, 2020, you had your California Consumer Privacy Statement or similar language baked into your privacy notices, unfortunately, yet again, there will be some additional changes required. Specifically, in addition to the content that has already been added based on the CCPA, the CPRA will require the following additional disclosures. First, the categories of personal information that the business shared for cross-context behavioral advertising. That's in addition to existing disclosures regarding PI sold. Next is information regarding the business's processing of sensitive personal information, as I just defined, including the categories of sensitive personal information collected, the purposes for which such sensitive PI is used, and finally, whether sensitive PI is sold or shared for cross-context behavioral advertising. Next is a requirement to specify the length of time that the business intends to retain each category of personal information. Now, that's a game changer in the US. Historically, we did not have to specify that in our privacy notice, unlike outside of the US where we've seen that before. They do note if such disclosure and specification of the retention period is not possible, you have to at least provide the criteria that are used to determine such period. And last but not least, notice requirement is to describe, of course, the new consumer rights, specifically the right to correction, opt out of sharing, and limits on the use and disclosure of sensitive PI. And with that, I will turn it over to Erin.
Great. Thank you very much, Brittany. Let's shift gears slightly and talk about some additional key concepts from the CPRA. These are going to include contracting requirements, some of the emerging obligations that are inspired quite directly by the GDPR in the EU, which Lisa alluded to, a couple of the key definitions and exemptions in the law, and then we'll finish up with a discussion of the new sheriff in town from a regulatory perspective, as well as how the private right of action will operate. Let's start here on slide 14 with the contracting requirements. So the CPRA includes requirements for contracts with third parties, service providers, as well as contractors. From a policy perspective, clearly there is an effort here to prevent an end run around the law's protections by moving data onward to various third parties, right? To avoid that end run, in all cases, the law requires your contracts to include certain prescribed content, which is listed here in the slide. This includes content specifying that the personal information in question is sold or disclosed by the business only for limited and specified purposes. The recipient of the data must be required by contract to comply with applicable obligations imposed by the CPRA and provide the same level of privacy protection as is required by the CPRA. In addition, the contract will need to grant the disclosing business the right to take reasonable and appropriate steps to help ensure that the recipients of the data are using the personal information in a manner that is consistent with the discloser's legal obligations under the CPRA. And if the recipient can no longer meet its obligations under the CPRA, the contract must require the recipient to notify the discloser of this fact. Lastly, the agreement must in all cases grant the disclosing party the right to take reasonable and appropriate steps to stop and remediate any unauthorized use of personal information. I note that these requirements I just went through apply to all contracts, whether they are with third parties, service providers, or contractors, all of which are terms of art. There are additional content requirements for contracts that you execute with your service providers and contractors, leaving out third parties for this part of the presentation. In particular, you are required to prohibit the service provider or contractor from selling or sharing the personal information within the meaning of those terms in the law. Okay, you're also required to prohibit them from retaining, using, or disclosing the personal information for any purpose other than the business purpose specified in the contract outside of the direct business relationship between the service provider or contractor and the business. And you must also prohibit the service provider or contractor from combining the personal information that they receive pursuant to the contract with personal information that they receive from or on behalf of another person or that they have collected directly from a consumer. There are a few limited exceptions here. Okay, for your agreements with contractors specifically, there are still further requirements with respect to mandatory content. These include a certification made by the contractor that the contractor understands the restrictions imposed on them and will comply with them. In addition, contractors must permit the disclosing business to monitor their compliance with the contract through various measures at least once every 12 months. You would be permitted to include this concept in your contracts with service providers as opposed to contractors. I know there's a lot of jargon here, but you are not legally required to do so as you are with your contracts with contractors. Note additionally that if you are a contractor or service provider, you also are required to notify your client, i.e. the business, if you engage another entity or person to process personal information, right? And you have to bind that other entity or person by contract to comply with the CPRA's obligations on the service provider or contractor. Let's move on to the next slide, please. One of the most interesting aspects of the CPRA is how much of it has been directly inspired by the GDPR, right? Concepts like proportionality, automated decision-making, and privacy risk assessments all straight from the GDPR, have been incorporated into the CPRA. Let's spend a few minutes talking through what this means as a practical matter under the law. Let's start first with the concept of necessity or proportionality. Similar to the GDPR's necessity and proportionality principle, under the CPRA, a business has to limit its collection, use, retention, and sharing of personal information to only that which is reasonably necessary and proportionate to achieve the purposes for which that information was collected or processed, or for another disclosed purpose that is compatible with the context in which the information was collected, and not further processed in a manner that is incompatible, right? In some ways, this issue has already been addressed in unfair competition law in the United States that already exists, which requires companies to not materially derivate from the promises that they have made to consumers regarding the personal information they collect and how they use it. But this is a little bit different and a little bit more explicit, right? Retention is a concept that I just mentioned here under the CPRA, and it's a concept that has to be addressed in EU privacy notices under Article 13 of the GDPR, but it is not a concept traditionally addressed in US privacy notices, right? Which means it tends to avoid the unfair competition scrutiny, or it has historically. But it is clear from the CPRA that companies are going to need to be thinking specifically about minimizing their retention of personal information to that which is necessary or proportionate to the purposes for which the data was collected, right? Most US companies have conditioned themselves to doing this in the context of data collection, use, and sharing. But those activities also need to be necessary or proportionate to be compliant, right? So this adds a layer of formality, to what I think is mostly something that US businesses are familiar with. But obviously, when you add the element of it being a legal requirement, specific legal requirement, as opposed to something that is regulated by state and federal unfair competition law, that's a bit of a game changer. Let's talk a little bit about automated decision-making. Okay, the rise of AI in automated decision-making has raised, I think, for all reasonable people, legitimate policy concerns in the EU that are focused on ensuring there are guardrails in place that are appropriate with respect to the use of automated decision-making engines, right? The CPRA is similarly focused on these tools, primarily with an eye towards ensuring that businesses provide meaningful information about the logic involved in these processes, as well as a description of the likely outcome of the process with respect to the consumer. The CPRA right now does not itself impose these obligations, but instead it requires that regulations be issued by July 1st of 2022, governing access and opt-out rights for Californians with respect to the use of automated decision-making technology, right? So clearly, conceptually, this is something to get your head wrapped around in terms of when you're using this type of technology, which is only going to grow in commercial applications. We're seeing more and more of them in practice, are going to need to be evaluated. And I think it's reasonable to expect that policymakers would expect some guardrails to be put in place around how these decisions are being made, right? And that's exactly what is going to be coming. Let's move on to security audits and privacy risk assessments. Similar to the GDPR's requirement to complete a data protection impact assessment in the event of high-risk data processing activities, the CPRA requires regulations to be issued again by 2022, July 1st, governing requirements for independent cybersecurity audits that need to be carried out annually, and for regular privacy risk assessments to be submitted to the California Privacy Protection Agency, which is the new agency Lisa mentioned that will be created under the CPR, which I'll get to in a little bit. These audits and assessments are going to be required for businesses whose processing of personal information presents significant risks to consumers' privacy or security. The purpose of the privacy risk assessment is going to be to weigh the benefits and the risks of the processing with the goal of restricting processing if the risks to the consumer outweigh the benefits to the other relevant stakeholders. Well, this has not been, this privacy impact assessment has not been a requirement before for most companies in the US. It has been a best practice emanating from the GDPR. So while this will add to the compliance burden, in our view at Hunton, doing privacy risk assessments effectively will have a significantly positive impact on your ability to mitigate privacy risk down the road, right? So again, while this is burdensome in some ways, in other ways, seen through another lens, it's a nice impetus for cultural change within your organization that will actually make your lives much, much easier down the road. Let's move on to slide 16. Let's talk here briefly about some of the key concepts in terms of that have been added to the CPRA. As the slide indicates, the law adds a definition of consent. It revised and adds new examples to the definition of business purpose. It expands the publicly available information exclusion from the CCPA. It clarifies the GLBA exemption, the Gramm-Leach-Bliley Act exemption. And it extends the general moratorium on the law's application, limited application to HR and business-to-business data to 2023. I know that was a welcome addition to the CPRA for many of our clients. So talk a little bit about consent. In the context of consent, again, mirroring the GDPR, the CPRA mirrors the GDPR's definition such that consent is defined to mean any freely given, specific, informed, unambiguous indication of the consumer's wishes. A number of adjectives that you may be familiar with if you have some scope to cover the GDPR. This comes straight from the GDPR, right? And importantly, and also similar to the GDPR, consent under the CPRA will not be valid if it is sought in the context of accepting a set of general or broader terms that contain descriptions of personal data processing, as well as other unrelated information. So this idea of getting consent to an entire policy or set of terms will be challenging to do here as it is under the GDPR. We'll, for the interest of time, skip a more detailed explanation of some of the issues that have been added around business purposes and publicly available information. I will mention, for those of you in financial services, the CPRA broadens and clarifies that the GLBA exclusion applies to personal information that is subject to the Gramm-Leach-Bliley Act, as opposed to the current articulation in the CCPA, which is an exemption for personal information that is processed, shared, sold, or disclosed pursuant to the Gramm-Leach-Bliley Act. That seems like a small distinction, but it actually could be significant depending on the nature of your activities. And I think it is a welcome change and something that you'll want to work through if you are in financial services or if you are receiving information from financial services firms who are subject to GLB, because GLB does have reuse and redisclosure obligations that apply to non-financial services firms who would then seemingly benefit from this broadening of the exemption here in the CPRA. But that is something that should be given some thought if it impacts your business. Let's move on to slide 17, please. So we'll shift gears here a little bit and close with a discussion about enforcement, which is always top of mind when any new regulatory regime emerges appropriately. So in particular, let's talk about the CPRA's establishment of the California Privacy Protection Agency and the modifications to the CCPA's private right of action provisions, okay? The CPRA establishes the CPPA, which is responsible for enforcing and implementing consumer privacy laws and imposing administrative fines, okay? In particular, the CPPA may investigate possible CPRA violations when they receive sworn complaints from anybody or on their own initiative, right? It's hard to say at this point, but the establishment of the CPPA as a dedicated privacy agency could result in more enforcement resources than are currently available to the California Attorney General, who is the entity within California currently tasked with enforcing the CCPA, but also many, many other laws, right? So this CPPA will be a more discreetly focused regulator. But note that until the CPRA starts enforcement in 2023, the CCPA enforcement authority will continue to rest with the Attorney General. Okay, in addition, recall that the CCPA includes a private right of action for data breaches that result from a company's violation of its duty to implement and maintain reasonable security procedures under California law under AB 1950, as we historically called it. The CPRA expands the private right of action slightly to cover data breaches that result in the compromise of a consumer's email address in combination with a password or security question and answer that would permit access to the consumer's account. The CPRA also clarifies that in this context, though the 30-day cure period from the CCPA still exists, the implementation and maintenance of reasonable security procedures and practices following a data breach would not constitute a cure with respect to that specific data breach. Speaking of the cure period from the CCPA, the CPRA gives the CPPA, I know it's lots of C's and P's and A's, the discretion to provide a 30-day cure period for an alleged violation, taking into account the lack of intent by the actor to violate the CCPA and taking into account any voluntary efforts that were undertaken by the business or the service provider or the contractor to cure the alleged violation prior to being notified by the CPPA of the complaint. The bottom line on the cure period here under the CPRA is that it's not guaranteed, but is instead conditioned on the underlying company's behavior. I think as a formal matter, that is a change. As a practical matter, I think it makes good sense what they have done here with respect to the cure period. Lastly, and before I'll turn it back over to Lisa, the civil penalty for CCPA violations will be replaced with an administrative fine. Amounts for the administrative fine will remain the same as the CCPA's current amounts for the civil penalty. And that, you will recall, is up to $2,500 per violation or $7,500 for an intentional violation. Violations of the CCPA involving the personal information of consumers whom the business or service provider or contractor subject to the law has actual knowledge is under 16 years of age will result in an administrative fine of up to $7,500 per violation. Obviously, there are many, many business models where there are data subjects in that 15, 16-year-old range. And this ups the ante on your compliance burden if you are one of those businesses. And some of our clients are in that space. And so this is something to think quite carefully about. It goes without saying that all of these numbers could add up quite quickly, which ups the ante on ensuring you have made reasonable efforts to develop appropriate compliance infrastructure to address these incremental requirements that are imposed by the CPRA. And we certainly are poised to assist you with that and are in a very good position to do so with the work that we have done under the GDPR, but also under the CCPA with our clients. With that, I will turn it back over to Lisa for some parting thoughts. Thank you.
All right. Thank you so much, Aaron and Brittany. So we now know the rules. So now what? You have a terrific CCPA compliance program. You worked hard to develop it. You were killing yourself last November, December to get it done in time for the compliance deadline. And you made your IT team crazy as well. And there was a big team involved in this push. Okay, so take a breath. and pull that team back together, and there is more work to do, but we have time. So, that's the good news. And there was certainly a thought in terms of the timeline to the 2 years that was granted in connection with GDPR compliance. And so now we have 2 years here, although don't forget about that 1 year look back. What needs to be done? You'll need to revisit your privacy notices to make sure that they are revised to incorporate the required disclosures that are new and different. But you're probably 80% of the way there already, so this is not horribly onerous. You'll need to update your internal policies and any tools that you have in place for consumers with respect to their exercise of their privacy rights. We're going to need to inventory, as we did previously, service providers, but now adding contractors and third parties to the extent there is a contractual requirement, and we'll need to push out new template language. This may be the most logistically painful of all the new provisions, because it's just going to require sort of going back to the till, which is just so difficult from a business perspective. We're going to need new policies and procedures around the collection, use, retention, and sharing of information to comply with the necessity and proportionality principle. And again, this is just not something we're terribly used to in the United States, and certainly hasn't been embodied in privacy law in the past in the US. We're going to need to think about sensitive PI, and that means inventorying your data, understanding where sensitive PI exists, and thinking about it not only in terms of sort of US obligations with respect to sensitive PI like Social Security number, but also some of the more common elements of sensitive data overseas, which is interesting and new in this country. We also need to think about our automated decision-making and figure out where we're doing any of that, and also think about cross-context behavioral advertising. We are going to need to develop audit and risk assessment frameworks. This is not a bad thing. It's good to do this generally, but it's not so good when it's mandated by law. The retention requirement is tough. Many companies do not have data retention schedules. They might have records retention schedules, but this is more about data than records. And I think that's very tough. There is an alternative given where you can indicate the criteria used instead of actually the time periods. So this is definitely something to think about. One really tough piece of this is that we now need to we knew we were going to need to do this anyway, compliance with HR, with respect to HR data and B2B data. But we have to sort of pull that data out. And then for that data, it's not just a question of tinkering with what we have in place already, but really starting fresh. And again, the compliance deadline is January 1, 2023. We have to update our training and conduct new training. And then, finally, there are new regulations that are coming. So we're going to need to really think hard about being nimble and letting the process play out as it will. So I'm mindful of the time. I want to thank you all for joining us for today's program. Please visit our blog at www.huntonprivacyblog.com. We post on the latest developments on these issues, as well as other privacy and data security issues all over the world. We look forward to having you at our future events. Thank you for joining us.